everyone. It's your commercial transaction sensei Enoch once again, and this is the 6th module of our wonderful journey, and I'm here to disturb you again. What I've come to disturb you with today is the subtopic passing of property. Passing of property. In this module, we are basically going to consider the specific goods aspect part of it. You know, when we're in the earlier modules, we're given the different types of goods, specific goods, uncertain goods, and co and co and co. Now, this is where it pays off to have listened to the first one. So, if you didn't, go back and watch it. It will really help, actually. So, our topic for this module is passing of property, mainly focusing on specific goods. So, the main objective of a contract of sale is to pass property. And property in this sense is ownership. We're not just talking about the physical possession of the goods or whatever. We're talking about ownership. When we say property, we mean ownership. So yeah, the main object of a contract of sale is to pass ownership from the seller to the buyer. And you have to realize that property is not necessarily linked to delivery or possession. It's possible that the goods have already been delivered to the buyer, but yet property is not in him. Or it's possible also that the goods are still in the seller's possession, yet property has already passed to the buyer. So we're going to delve into that today. And the reason why passing of property is actually very important is that it comes up a lot of times in insolvency situations when a business or someone goes bankrupt and they are trying to determine who are the secured creditors and the unsecured creditors and stuff like that. And also because otherwise agreed, if not otherwise agreed, risk usually transfers with property. Meaning that if property has transferred to you, the risk of whatever happens to your goods also transfers to you. So section 16 to 19 deal with the transfer of property from the seller to the buyer. Section 16 to 19 of the Sale of Goods Act of 1893 of SOGA, like we always say, is a statute-based course. So we are quoting it, it's our Bible, always quoting it every time. So dealing with specific goods, we have to start from section 16. And section 16 says that where there is a contract for the sale of unascertained goods, no property in the goods is transferred unless and until those goods are ascertained. Section 16 says that where there is a contract for the sale of unascertained goods, no property in the goods is transferred unless and until those goods are ascertained. Just keep that in mind. When we are about to start treating transfer of property, the unascertained goods aspect is going to come in handy. So now we move to section 17. This is the starting point when considering whether property has passed or not in regard to specific goods. So section 1 says that property in specific or ascertained goods passes to the buyer when the parties intend for it to pass. There's something about commercial law. You usually try to take cognizance of the wishes of the parties. So in many of their stipulations, you will always see that they put the wishes of the parties above the stipulations of maybe statute or whatever. So it goes almost the same thing here also. Section 17.1 states that property in specific and ascertained good passes to the buyer when the parties intend for it to pass. That's the general rule. And to determine this, they usually consider maybe the terms of the contract, the parties' conduct, their representation or whatever, and the circumstances of the case to determine when the parties intend for the property in the goods to pass. And if we still can't decipher the intention of the parties as regards passing of property, then we move on to section 18. That's when section 18 of the Sale of Goods Act of SOGA comes into play. Now, section 18 gives 5 rules to help determine when property has passed if the intention of the parties does not make this clear according to section 17 sub 1. Please keep that in mind. So 5 rules. Rule 1 to 4 deal with specific goods, and rule 5 deals with unascertained goods. So we are going to deal with rules 1 to 4 here. Like we said before, we're dealing with specific goods transfer of property in this module. So rule 1 goes thus: that where there's an unconditional contract for the sale of specific goods in a deliverable state, the property is transferred when the contract is made even though payment or time is postponed. I'm going to take it again. That where there is an unconditional contract for the sale of specific goods in a deliverable state, the property is transferred when the contract is made, even though payment or time is postponed. Please and please, it will be very, very useful to get a copy of the Sale of Goods Act 1893, because there are some of these things you have to look at them word for word. Like now, in this provision I just read out, there are things that are very, very important. It says where there's an unconditional contract, meaning that the contract must not be subject to something, must not be a contract based on subject to contract or subject to some other thing being done. It must be unconditional, and it must be for the sale of specific goods. And the specific goods must be in a deliverable state. Well, I'll be like bicycle. Everything is inside and out. So like that. Unconditional contract for the sale of specific goods in a deliverable state. And this is when property is transferred when the contract is made, even though payment or time is postponed. As long as those requirements are fulfilled, the property is transferred when the contract is being made. Immediately the contract is being signed, even though you have not even delivered the goods yet, even though payment has not been given yet. So in the case of Talabi versus Mandolas Limited, Talabi and Mandolas Limited, the plaintiff paid for a vehicle. It was registered in his name. It was registered in his name already, but the vehicle was still with the defendant, the seller. And then the defendant refused to release the vehicle, claiming that the price had become higher. You know the wonderful vendors we have in this country called Nigeria. So he refused to release the vehicle, claiming that, that the price has gotten higher, that guy should pay more to get a vehicle that he has already paid for and is already registered in his name. The court held that property had already passed, regardless of the fact that delivery was postponed, and regardless of the fact that the seller was still in possession of the vehicle. As long as property had already passed to the buyer, property had passed, even though delivery was postponed. But there is an exception or a limit to this rule. And the limits, like I mentioned before, the contract must be unconditional. There must be specific goods in a deliverable state. And what does it mean for something to be in a deliverable state? It is that which is in such a condition that the buyer would, under the contract, be bound to take delivery of them as they are. And this is according to section 62 sub 4 of SUGA. Section 62 sub 4. It gives a definition of what a deliverable state means. A condition that the buyer would, under the contract, be bound to take delivery of them as they are. Meaning that there is nothing else left to be done to the goods or whatever for them to be delivered to the buyer. That means that they're in a deliverable state. Not that you have to start unbolting something or rearranging something or disassembling anything. They're already in a deliverable state. So it means that, it means that if the seller agreed to do something to the goods before the buyer is to take delivery under the contract, then the goods are not in a deliverable state. Meaning that if there's a condition that, the seller has to do something, maybe if you are trying to sell a car and the seller has to change the tires of the car or something, the goods are not yet in a deliverable state. In the case of Underwood Limited versus Burr Castle Brick and Cement Syndicate, Underwood Limited versus Burr Castle Brick and Cement Syndicate, a condensing engine was the subject matter of this contract. It was sold, but it was bolted to the ground because it's like a very heavy machinery. You have to bolt it to the ground because of vibrations and stuff like that. So the contract required the seller to deliver the engine free on rail. That means detached and disassembled and everything. So while they were disassembling and detaching this engine from the ground, it was damaged. In such a scenario, one would imagine that, then who takes the liability for the damage? Is it the person for whom they were disassembling the goods for, or the person that was the owner before the goods started being disassembled? The court held that property hadn't passed as the machine wasn't in a deliverable state yet at the time of the contract. Remember our rule 1, it has to be an unconditional contract. The goods in question have to be in a deliverable state. So we move on to rule 2. Rule 2 goes thus: when in a sale of specific goods, the seller has to do something to put them in a deliverable state. The property doesn't pass until the thing is done and the buyer has notice that it is in that state of final delivery. Rule 2 is more like an extension of Rule 1, if you notice. is more of like an extension of Rule 1. It says that where in a sale of specific goods, the seller has to do something to put them in a deliverable state, and the property does not pass until the thing is done, and the buyer has notice. The buyer must have notice in Rule 2. Not only must the thing be done to put it in a deliverable state, the buyer must have gotten notice that yes, that the goods he wants are already in the final state of delivery. Now we move on to Rule 3. Rule 3. Rule 3 states that where there is a sale of goods in a deliverable state, but the seller is bound to measure, test, weigh, or do other acts to the goods for ascertaining price, property doesn't pass until this is done and the buyer has notice of it being done. Yes, I'm going to take that again. That where there's a sale of goods in a deliverable state, the goods are already in a deliverable state, already in this Rule 3, but the seller still has to measure or weigh it or test it in order to determine the price that will be attached to it. So property does not pass until this is done and the buyer has noticed that it has been done. You know, there are some goods that when you want to buy them, they have to measure them to determine what the price will be. There are goods like that. And in the case of Nanka Bruce versus Commonwealth Trust Limited, Nanka Bruce versus Commonwealth Trust Limited, it was on this rule where a party sold cocoa to another party, cocoa, C-O-C-O-A, to another party at an agreed price per measurement, another kind of thing, you have to measure it, and cool. So, and then the other party was to later resell. In that case, the court held that the weighing didn't make the contract conditional. It didn't make the contract conditional as the price payable was already determined. You know that I said earlier that they already had an agreed price per measurement. So even though they were still measuring, there was already a price established per measurement. So it was not as though the measuring was a condition to the fulfillment of the contract. So it held that the weighing didn't make the contract conditional as price payable was already determined and that property had already passed to B before the price was ascertained. Straightforward, simple, to the point. Now we come to Rule 4. Rule 4 states that where goods are delivered to the buyer on approval or on sale of return, the property passes when, let me speak it in normal English without the old archaic statute, whatever. What they mean by on approval or on sale of return is like, you know, in situations where you go to the market and then the seller tells you that, oh, don't worry, take it, it's good, it's your size, is what you want. If it's not what you want, don't worry, bring it back to me. And those stuff, you know, some Nigerian vendors can be very, very extreme when they want to sell you something by force. So in those kinds of situations, is on approval or sale or return. And so property passes in that kind of situation in under two instances. A, when the buyer signifies his acceptance to the seller or does any act adopting the transaction. You know, if you buy a shoe from a vendor and then you have worn the shoe up and down the streets of Lagos and mud has already covered it, and then you want to return it and later say that, oh, Kinikon, they won't answer you. Because in that kind of situation, you've already done an act adopting the transaction of that sale. So when the buyer signifies his acceptance to the seller or does any act adopting the transaction, there's a case for that, Kirkham and Attenborough, that an act adopting the transaction means an act inconsistent with him being anything other than a purchaser. That means that the act is something that it shows clearly that yes, you are a purchaser. Like when you have bought something on sale or return and then you use that same thing as a pledge or something, or as a collateral for a loan, you have done an act adopting your original sale transaction. Because it does not make sense. Why pledge something that you do not own? And then the second subheading under this rule is that property passes when and if it retains the goods without giving notice of rejection beyond the time fixed for the goods return. Like if you have been given a time that, oh, if you don't like the goods, return it tomorrow, and yet you don't return it tomorrow, you want to bring it back next week, Baba, you've already bought it. Property has passed to you. Even though you might not have paid, property has passed to you and they can sue you for the price. And if there is no fixed time for return beyond a reasonable time, You can't keep something in your place for a long, extended period of time and then claim that there was no express sale. In the case of Poole and Smith's Car Sales Balaam Limited, Poole, Poole, and Smith's Car Sales Balaam Limited, it was held that in that case, that since both parties treated it as a contract of sale or return, the property had passed to the defendant as he had retained the car beyond reasonable time and was liable to pay the price. In that case, what happened was that the plaintiff, they were both car dealers. The plaintiff wanted to store his car at the defendant's place, and under the condition that, oh yes, the defendant can sell the car, but he has to pay the plaintiff a particular amount of money. But the defendant kept the car for an extended period of time, and the thing got damaged, and the plaintiff wanted his car back. The plaintiff wanted his car back. When he discovered that it was damaged, he didn't want it back anymore. He wanted the price, and the defendant claimed that, oh, there was no express sale, it was a sale or return kind of, that there was no express sale, that it was just with it. And then the court held that he had held the car beyond reasonable time, and that therefore he was liable to pay the price. There is an exception to this. Our favorite word, exception. The exception was laid down in the case of referium. The exception is that a buyer is not deemed to have adopted a transaction by retaining the goods if he is prevented from returning the goods by forces outside of his control. If he is prevented from returning the goods by forces outside of his control, it cannot be said that, oh, it cannot be said that he has adopted the transaction by retaining the goods. That's what that case held. So please, I would like us to like, to share, to comment, to subscribe. Please share with your friends. Cut hope for them. There's no point in you passing if you are the only one there. Everybody wants to pass, but share with them. Thank you, and this has been Learning with Your Sensei. See you in the next module.